56% of American adults have no estate plan at all. No will, no trust, no medical power of attorney, nothing. And 42% say they would not know what to do if a family member died today. That is not a paperwork problem. That is a family standing in a courthouse hallway, learning the rules for the first time on the worst week of their lives. So let's fix that. Living trusts start to finish. Here is the thing. Nobody explains properly. Everything you own is titled in somebody's name. Your house, your bank account, the car in the driveway, the rental property you bought in 2011 and still brag about while you are alive. That name is you. The moment you stop existing, that name still exists, and it is attached to property that now has nowhere to go. So somebody has to move it. And there are only 3 ways that happens. The first way is that you did nothing. Lawyers call that intestate. Your state legislature wrote your estate plan for you decades ago without ever meeting your family. Your assets get divided according to a statute, and your family gets to argue about it in open court. Aretha Franklin died in 2018 with an estate valued around $80 million and no coherent plan. 4 different wills eventually surfaced, one of them handwritten and found in a couch cushion. It took a jury in Pontiac, Michigan to decide which one counted. By 2020, the lawyers had billed her estate over $586,000. Prince died with no will at all, and untangling his estate took 6 years. The second way is the one your neighbor swears by, a will. And I need you to hear this clearly because it is the single most expensive misunderstanding in American estate planning. A will does not avoid probate. A will is instructions for the probate judge. It is a greased slide into the exact process you are trying to escape. So what is probate really? It is a court proceeding to change the name on your stuff. The court opens a file. Creditors get notified and given months to make claims. Beneficiaries get notified and given a chance to object. Nationally, that runs somewhere between 9 and 24 months. And costs roughly 3 to 7% of the gross value of the estate. In California, the fees are set by statute. A $500,000 estate generates about $26,000 in statutory, attorney, and representative fees. A $1 million estate generates about $46,000. Before court costs, before appraisers, and it is public. Every asset, every debt, every beneficiary. Anyone with a library card and an afternoon can read the whole thing. Now add real estate. If you own property in more than one state, your family does not get one probate. They get a separate ancillary probate in every state where you own dirt. Different courts, different lawyers, different timelines, running at the same time. And then there is the part that has nothing to do with money. About 3% of wills get contested, and a contested case runs 2 to 3 times longer than a normal one. I have watched siblings who genuinely loved each other stop speaking over a set of Christmas plates. Grief and greed live in the same house. Add lawyers and a courtroom, and you have handed them a stage, which brings us to the third way, the living trust. A trust has 3 roles: the person who funds it, the person who manages it, the people who benefit from it. While you are alive and healthy, all 3 of those people are you. You are not giving anything away. It is revocable, which means you can change it, amend it, or tear it up on a Tuesday afternoon because you changed your mind. You still live in the house. You still sell it if you want. You still take the capital gains exclusion. And if you need to refinance, the lender may ask you to move title out temporarily and put it right back at closing. Under the federal Garn Saint-Germain Act, transferring your residence into your own revocable trust does not trigger the due on sale clause. Then something happens to you, and this is where the trust earns its keep. Twice, not once. Roughly 1.3 million American adults are currently under a court-supervised guardianship or conservatorship, with something like $50 billion in assets managed under court oversight. Those are people who did not choose who would speak for them, so a judge chose instead. A properly built living trust names your successor in advance: your spouse, your sibling, a bank, an attorney, somebody you actually trust, chosen by you on a good day in a quiet room. And when you die, there is no courtroom. Your successor trustee takes a death certificate and a certification of trust to the bank, and the machine simply keeps running. Trust administration commonly wraps in weeks rather than the year or 2 probate takes. It is private. There is no file for the neighbors to read. Now, let me be the attorney who tells you the uncomfortable parts, because most of the internet will not. A revocable living trust does not protect your assets from your own creditors while you are alive. You control it, so the law treats those assets as yours. It does not reduce your estate tax. And in 2026, the federal exemption sits at $15 million per person, $30 million for a married couple. So for the overwhelming majority of families, estate tax was never the point anyway. And an unfunded trust is worthless. This is the failure I see most often, and it breaks my heart every time. Somebody pays for a beautiful trust, puts the binder on a shelf, and never retitles a single asset. The house is still in their personal name. The brokerage account is still in their personal name. That family goes straight into probate holding a document that promised them they would not. Fund it. Deed the real estate. Retitle the accounts. Check the beneficiary designations on the retirement accounts and the life insurance, because those pass by designation and not by your trust. Review the whole thing every 3 to 5 years and after every marriage, birth, death, or move. And understand that the trust is not the whole plan. It travels with a pour-over will to catch anything you forgot. A financial power of attorney, a medical power of attorney, a HIPAA authorization, and a nomination of guardians if you have minor children. A will only works after you are dead. This package works while you are alive, while you are unable to speak for yourself, and after you are gone. There is nothing else that covers all three. One more warning. State attorneys general in California, Pennsylvania, and elsewhere have spent years chasing what they call living trust mills. Somebody runs a free seminar at a church or a retirement community, sells a boilerplate trust, then uses your financial information to push you into an annuity you did not need. If the person across the table is more interested in your account balances than your family, walk out. Now here's the part I actually care about, and it is not the probate math. A will answers one question. Who gets my stuff? A trust answers better questions. When do they get it? Under what conditions? Who protects it if the person receiving it is 23, or in the middle of a divorce, or fighting an addiction, or simply cannot be trusted with a lump sum yet? You can hold a share in trust. You can tie distributions to health, education, maintenance, and support. You can say the money is there for tuition and rent and emergencies and not for a Lamborghini. You can even say something strange and beautiful like, every year this trust will pay for you to leave the country for 2 weeks and learn how somebody else lives, because I thought that mattered. That is not a document. That is a voice, yours still talking, long after you have stopped. And the timing on this is not abstract. Carulli Associates projects roughly $124 trillion will change hands in the United States through 2048. About $105 trillion of that goes to heirs. This is the largest transfer of wealth in human history, and more than half of the people in its path have not signed a single document. The excuses are always the same. The most common reason Americans give for having no plan is that they do not think they have enough assets. That is the misconception that does the most damage. This was never about being rich. It is about whether a judge or a person you chose decides what happens to your children, your medical care, and your home. So do the honest version. Find out what your state's probate actually costs. Ask whether your assets are titled where you think they are. And if you already have a trust sitting in a binder, open it and check that it owns anything at all. Because everything you own is titled in somebody's name. Right now, that name is you. The only question left is whether you choose what happens next, or whether a stranger in a black robe does it for you. 18 months from now, with your family sitting in the second row, choose. It is the last decision you get to make, and it is the only one that outlives you. If this was helpful, subscribe to the channel and like the video. There's a lot more coming.